Mr. Nkoyo and the team for a very detailed and penetrating discussion. First of all, I want to comfort you that as members of Parliament, we will do justice to your views. And just to remind you that this particular bill was initially brought by some of our colleagues who are MPs. The Honorable Hilary Chiyaga, supported by the Honorable Rachel Magola. Eventually, government took it over. So we are very passionate about it, and we associate with this bill because it was brought by our colleagues. So I want to comfort you that we will try as much as possible to ensure that your views and your interests are captured, because we also your representatives. So when government took it over, they brought it here to us to scrutinize and listen to all of you. So these views that you've given will form part of the report that we are going to make and then submit to the entire House for all the other members of Parliament to have an input, because we are merely a committee of the entire Parliament. But as far as we are concerned, as members of the Legal and Parliamentary Affairs Committee, we will do justice. So I want to comfort you in as far as that issue is concerned. Thank you. Secondly, Mr. Chairman, just a few clarifications that I intend to seek from Mr. Nkoyo and the team. You seem to express discomfort with clause 5, which is amending section 13, registration of contracts. And you are saying it should be optional. I want to understand what would be your discomfort in having the contracts of assignment, license, and transfer registered. Where is the problem? Where do you find the discomfort? No,
Mr. Nkoyo, hold on. You note them down.
Yes.
You respond at once.
Yes, because my understanding is that registering has more advantages than disadvantages. And I speak from a professional point of view as a practicing lawyer, not necessarily as a creator. Maybe we may have different perspectives, but just to understand why you would be uncomfortable with the requirement for registration. Number two, Mr. Chairman, is on the issue of reversion. Clause 6, reversion of copyright. You also seem to be uncomfortable with capping it at 20 years. And in your view, this copyright should exist in perpetuity. That's how I have understood you. I am not so sure whether there is international consensus on making it open-ended. I'm not so sure. Because I am aware of certain countries where actually reversion is capped. I'm aware there's some jurisdictions actually cap reversions. Here there is a proposal for 20 years. Your view is that it should not even be increased or decreased, it should be scrapped. I also want to understand your discomfort in capping the reversion of copyright. Thirdly, Mr. Chairman, is just to make a few clarifications from my part on the issue of rules. When you were discussing clause 12, amendment of section 41, the quasi-judicial powers of the registrar, you seemed to be uncomfortable with the regulations as opposed to specific provisions in the Act. And for example, you are saying that the statutory procedural framework should actually come in the Act itself and not necessarily in the regulations. Again, speaking from experience as a legislator here and as a lawyer, you should not worry about that. When Parliament decides to divest some of its authority to what we call subsidiary bodies to make regulations, we are not in any way diluting an Act. But you see, at the same time, an Act cannot be impregnated by everything. An Act has limitations. There are things that we reserve for the Act, and there are things that will come from what we call subordinate legislation. But even when we create or we empower either a minister or an agency to create subsidiary legislation, we give it the same force, okay? For example, it is possible for a regulation to create a fine. It is possible for a regulation to create a punishment. So you don't have to worry where it is placed. I think what is important is that, because you see, even when we empower, even when Parliament empowers a minister to make regulations, they guide that minister on those aspects that the regulations should cover. So if tomorrow, Mr. Nkoyoyo, this Act comes out and this particular issue is not reflected in the Act, but the Act is empowering the minister to make regulations to cover that, it will have the same effect, it will have the same force of law. So I thought that should not bother you. It is something that we will ensure. Chair, there are issues, again, that you will not make a subject of legislation, either principal or subsidiary. And here, for example, you cannot say you include a provision in the Act of recusal, automatic recusal. It will not happen. It will not happen. The recusal will happen, but it cannot be as a matter of law. So if you are uncomfortable with the presiding officer in either a judicial or quasi-judicial body, then you make a formal application to him or her, giving reasons why they should recuse from a matter. So it cannot be direct, okay? Otherwise, you are going, first of all, you are going to create assumptions that when somebody takes a decision, they are definitely biased or they are conflicted. And with due respect, which would be unfair, I think we should do, because whether you state it in the law or not, where somebody has discomfort in a presiding officer or judge, they will make an application for recusal depending on the reasons and circumstances, okay? So because here I was seeing our brother saying that, you see, there should be express statutory duty of a registrar to recuse themselves, okay? This is a legitimate concern, but it cannot be statutory. It cannot. And this does not take away your right to ask an officer to recuse themselves from a matter. So I thought we'd make that clear. It also applies to the issues of the ones you are saying that orders of the registrar should be stayed pending an appeal to avoid prejudicial enforcement. You see, again, you are not going to deviate from the conventional principles of law. An appeal per se does not operate as a stay. And the chair here is a distinguished lawyer. If you want a stay, you make an application for stay. It's really as simple as that, okay? So there is not going to be an automatic stay simply because you are making an appeal against the orders of the registrar in his or her quasi-judicial functions. And these are things that are already established in our judicial practice. So just don't get worried about them, okay? They will come and they will indeed help us. Now, Chair, I think the second last issue that I would raise, no, it's not the very last issue. You know, this bill here, one of the things it is doing is domesticating. It seeks to domesticate many international conventions of which Uganda is a party. In fact, Chair, for me, one of my reasons for supporting this bill is that Uganda as a country has international commitments and obligations. We agreed, we willingly signed these treaties. Now we have a duty under this law to have all those treaties domesticated so that they become part of our law. Now, once we have them domesticated, it means that we must align all our laws to suit those international treaties. We must align them. Even where there are laws internally, Chair, that conflict with those treaties, we have an obligation to change those domestic laws to satisfy the provisions of these treaties. So that is something I think that we need to highlight. We have an opportunity, and there are really very many, as he has highlighted them and as others have highlighted them. So it's important that we should not even be looking at just certain provisions within these treaties, but the entire provisions in the treaties. We have a duty to domesticate every provision. And you see, Chair, I know we always make a mistake, and I was discussing with our legal team here. You see, in the law of treaties, once a country willingly and voluntarily signs a treaty, we are bound by it. If there are laws in our country that conflict that treaty, it is up to Parliament to change the laws to ensure that they match with the treaty. In other words, and I don't want to take you into a lecture of international law and treaties, but I've been telling colleagues that, in other words, international law is superior to domestic law, what lay people call domestic law. But technically here it is called a municipal law. So international law is superior to municipal law. And the International Court of Justice has said in several cases that they call advisory opinions, that a country cannot hide under domestic law to circumvent its obligations under international law. So when you enter, and if there's a provision in a treaty you are uncomfortable with, at the time of signing you say so. It is called the reservation clauses. Okay? The Muslim countries, the Arab world, when they are negotiating treaties and the UN, especially those that relate to families, women, they always express reservations because they are very clear. We Muslims are very clear. We don't sign a treaty that, for example, says monogamy is the only thing. We will not sign it. So you'll find the countries in the Arab world saying, no, that particular clause will not bind us. But they will do what? They will sign. So you reserve. It's called the reservation of treaties, reservation clauses. So, but in our case as Uganda, Mr. Chairman, I have researched. We have not had any reservation clauses in any of these treaties. We have not had any. So what that means is that these people, this team here, are right to hold us as MPs accountable to ensure that all the provisions of these treaties are domesticated. I thank you, Mr. Chairman.
Thank you. The Honorable Haji Asuman Basalirwa Salongo. I already expressed from the beginning the depth of knowledge Mr. Nkoyo and the team exhibited in their presentation. I have a concern where you express, not explicitly, lack of knowledge by the beneficiaries of this law, and you demand for plain and simple language in the drafting. I expected Asuman to hint on it, that there are minimum standards in legislative drafting that must be adhered to. So we may need it to appear as plain as possible, but we may not go below certain standards. And just like we cannot assume total knowledge about the creative industry, and we seek a lot of knowledge from you, we always implore many artists where they are lacking in knowledge in a particular area, if it's legal, to get the services of lawyers to give them a proper interpretation of some of these clauses. So we may not be very categorical on the plain and concise language as you want it, because there are standards of legislative drafting. So I wanted to make that clear. Now, on the issue of a caretaker, there seems to be a scenario where a caretaker may be needed in the circumstances. Now, for avoidance of repetition of the scenario that you alluded to, why would it be convenient to suggest a time frame within the caretaker can act maybe and say should not exceed 6 months or this particular period of time, so that
that is actually provided for in the law.
Yes.
It is 3 months.
3 months.
Yes, that is the timeline.
Oh, okay. Then I know in so many instances and so many companies limited by guarantee, especially where we have board members masquerading, and I will use that word deliberately, as volunteers, there is always an inability. There is always an inability to call annual general meetings deliberately, and so the purpose, and I put it in quotes. Please don't misquote me. There is always a deliberate attempt by the people in leadership to deliberately fail to call annual general meetings. And the spirit of this provision is to ensure that there is adherence to the requirement. You see, when you assume a responsibility voluntarily, then it must come with obligations that you must meet. So I really wanted your a more honest opinion on the issue of annual general meetings and failure to set. We may look at the penalty as too harsh, but leaving it plain also creates other problems that the Act is trying to run away from. And so it creates a challenge. And then lastly, the Honorable Asuman talked about the statutory safeguards. I wanted also to allay your fears that not everything will be in the law, but certain things have been adopted generally by operation of the law, by legal practice and so many things. So I want to allay your fears. We seek knowledge from you because this law is your law. So wherever it is lacking, we expect you to enrich us deeper. And we assume that the Attorney General has also made a lot of comparisons, that if you give us the information, then we get an opportunity to do a comparison and see what is best for the industry. This is your industry. Whatever you suggest, we take it very serious because you know it more than we do. And so we take these recommendations you've made very seriously, and there will be a very, very instrumental guide when we are making decisions that we shall present to the floor of the full House to adopt. We make a very persuasive report, given the fact that we have heard from the real owners of the law that it intends to benefit. I want to give you only 2 minutes to respond to some of the concerns that the Honorable Basalirwa, and I'm very strict on time because only 2 minutes. The issues he raised, he knows the answers, and I also know you know the answers, so I'm giving you strictly 2 minutes so that we close this up and have another team.
Let me thank you, Chair, and let me first react to your very last concern about the annual general meetings. We are not saying or justifying that the executive committee should not be held accountable for the annual general meeting, because actually when you look at the Principal Act, there are already provisions taking care of that what happens when that happens. And I did raise in my submission that the point is not the lack or absence of the law. The issue has been the lack of the enforcement of the law. We are saying if we go past our 12 months, past 3 months after the calendar year and we've not held an annual general meeting, we are not saying we should not be held accountable, because we've made a commitment that we shall host it. But there are provisions in the law. I implore you to take a look at clause 7 of subsection 7 of section 70 of the Principal Act. It is already catered for there that what happens when an annual general meeting does not happen. Yes.
So look at the provisions of the Companies Act in line with this?
To be true, in line with this, no, I did not.
Okay.
Yes. Then, away from that, I want to thank Honorable Basalirwa. Thank you for building our confidence on the domestication of the international treaties. Because so many times people think we can act in a vacuum or like as if we're on an island. So we thank you for the confidence that you built in us about the domestication of the international treaties that we are part of. Then on the quasi-judicial powers, Honorable, I implore you to actually, my own personal recommendation would be to repeal that particular provision. But then from discussion with colleagues, it's a collective, they said, no, we can perhaps have it, but then, because it has a real danger, and the real danger is the conflict of interest. As I did say, Honorable, that remember the registrar is not a neutral standalone body, but the registrar is still the one who regulates, so they are going to become the judge, and then they become everything. So there's going to be a very, very big conflict of interest. So I still implore this House that please, when looking at that particular clause, pay close attention there. Maybe it may necessitate going into a little detail on what should happen and what should not, if you so choose that it should stand. And then finally, on the reversion, where is my discomfort? My discomfort is in what you very say, the international treaties. And then international foreign investment, big time investors, they need to have the sense, the feeling that, there is longevity. Because, for every formidable businessman, they don't plan well hoping that they will get their return on investment immediately, but they plan in the long term. And then also, secondly, is that the fact that I implore you to look at that, if you go to a piece of land, and why should it be with only our property, the intellectual property, that should have a cap? Why don't we have a cap that if I bought your land, I only have it for 20 years, and then it is reversed to you, back to you? So there's something you need to look at very critically there, and that is embedded in, as I did quote in the Principal Act, that we may look at it as movable property. And then lastly, you also asked about where's my discomfort on the registration, on the mandatory registration of our contracts, our works, and what have you with the registrar. Let me still begin with using the analogy of land. We all know that the legitimate certificate that shows that you are the rightful owner of a piece of land in Uganda is a land title. We agree. Does that invalidate that if you sold land to me and we made an agreement, does it invalidate it? No, it does not. Yes, but that is what we are saying. We are saying, we are not saying do away with the registration, but we are saying do away with the mandatory. We are saying create incentives, just like one would know that, hey, I'm safer with a land title than with just an agreement.